In 1842, deep in Mobile, Alabama, a secret unfolded that could have cost two people their lives. A wealthy widow, expected to uphold every rule of Southern society, quietly broke the most dangerous law of her time. She didn't just free her late husband's slave. She secretly married him. Their forbidden union was whispered about in alleyways, hidden in church records, and buried by families who never wanted the truth to surface. Today, we dig up the scandal Mobile hoped would stay forgotten forever. Before we begin, hit that subscribe button and drop a comment telling me where in the world you're watching from. It helps these hidden stories reach more people. In the winter of 1979, a graduate student named Margaret Thornhill was cataloging damaged court records in the basement of the Mobile County Courthouse in Alabama. The documents had survived a fire in 1902, and many were barely legible, their edges charred black, their ink faded to ghosts of words. Margaret had been working through probate files from the 1840s for 3 months. She was tired, she was bored, she was ready to give up on her thesis. And then she found it. A marriage certificate dated November 12, 1842. The groom's name, Samuel, identified as a colored man, formerly enslaved. The bride's name, Catherine Eliza Wardlaw. The officiant, Reverend Thomas McKinley of the First Presbyterian Church. The witnesses, 3 prominent merchants of Mobile, all white men, all pillars of the community. Margaret stared at the document for 20 minutes without moving. She later told colleagues that she forgot to breathe, because what she was holding in her hands should not have existed, could not have existed. In 1842, in the state of Alabama, marriage between a white person and a person of African descent was not just forbidden by law. It was a criminal offense, punishable by imprisonment, by social destruction, by violence that the state would not prevent and often encouraged. Yet here was the proof. Signed, witnessed, recorded in the official registry of Mobile County. Margaret Thornhill spent the next 8 years researching what happened. She interviewed descendants. She traveled to archives in 5 states. She found letters, diaries, newspaper articles, and court documents that painted a picture of something that should have been impossible. A story that challenged everything historians thought they knew about the antebellum South. About race, about power, about love in a time when love across the color line was considered an abomination. This is that story, and I need to tell you right now. You think you know how this ends. You think you can predict the trajectory of what happened to Catherine Wardlaw and the man she married? But you're wrong, because what actually happened is stranger, more complex, and more devastating than any ending you could imagine. Let me start at the beginning. Catherine Eliza Wardlaw was born on March 3, 1809 in Charleston, South Carolina. Her father, Edmund Wardlaw, was a shipping merchant who had made his fortune in the cotton trade. Her mother, Eliza Barnwell Wardlaw, came from one of Charleston's oldest families, a lineage that traced back to the colony's founding. The Wardlaws were not the wealthiest family in Charleston, but they were comfortable. They owned a 3-story house on King Street. They employed 12 enslaved people. They moved in circles where everyone knew everyone else's business, and reputation was currency. Catherine was the third of 5 children and the only daughter to survive past the age of 10. Her 2 sisters died of yellow fever in 1816, when Catherine was 7 years old. This fact matters. We'll come back to it. She was educated at home by a governess, as was customary for girls of her class. She learned French, music, needlework, and enough mathematics to manage a household, but not enough to threaten her future role as a wife. She read extensively, which was less common. Her father's library contained over 300 volumes, and Catherine was allowed access to all of them. She read Shakespeare, Milton, the Greek philosophers in translation. She read Mary Wollstonecraft's A Vindication of the Rights of Woman, which her mother disapproved of, but her father defended. "Let the girl think," Edmund Wardlaw reportedly said. "She'll be told what to think soon enough once she marries." Catherine's childhood was, by all accounts, ordinary for a girl of her station. She attended church every Sunday at St. Michael's Episcopal Church. She participated in charity work organized by the Ladies' Benevolent Society. She learned to play the piano with adequate but not exceptional skill. She was described by contemporaries as pleasant in appearance and of good temperament, which were the highest compliments typically given to young women who were neither extraordinary beauties nor troublemakers. But there was something else, something that appeared in letters and diary entries from people who knew her, a quality that's difficult to name but impossible to ignore once you start looking for it. She asked questions. In 1825, when Catherine was 16, she attended a dinner party at the home of Judge William Harper, a prominent attorney and later a justice of the South Carolina Supreme Court. The conversation turned to the question of slavery's expansion into new territories. Judge Harper, who would later become one of the most influential pro-slavery theorists in the South, argued that slavery was not merely a necessary economic institution, but a positive moral good that elevated both the enslaved and the enslaver. Catherine asked him a question. The exact words aren't recorded, but we know it happened because Judge Harper mentioned it in a letter to his colleague, John C. Calhoun, 3 days later. He wrote, "Young Miss Wardlaw asked me to explain how the condition of perpetual bondage could be considered an elevation for the African, when Christ himself commanded that we free our servants in the 7th year as instructed in Deuteronomy. I found her question impertinent, but could not fault her biblical scholarship." This was dangerous. Not the question itself, but the act of asking it. In Charleston in 1825, there were things that everyone knew but no one said out loud. The system of slavery depended on a collective agreement to maintain certain fictions, that enslaved people were happy, that they were childlike and incapable of self-governance, that the system was ordained by God and beneficial to all parties. To question these fictions was to threaten the entire social order. Catherine's father pulled her aside after the dinner party. "We don't know what he said, but we know that Catherine stopped attending large social gatherings for several months. She spent more time at home. She spent more time with the enslaved people who worked in her father's house. And she spent time with a boy named Samuel. Samuel was approximately 2 years older than Catherine. He had been born enslaved in the Wardlaw household, the son of a woman named Dinah who worked as the family's cook. His father's identity was not recorded in any documents, which tells you something in itself. In the world of Charleston slavery, silence often meant shame, and shame usually meant that a white man had exercised the power he believed was his right to exercise over a woman who had no legal ability to refuse him. Samuel was trained as a house servant. He served at the Wardlaw family table. He accompanied Edmund Wardlaw on business trips to the docks. He was taught to read and write, which was illegal under South Carolina law, but commonly practiced among wealthy families who needed enslaved people capable of handling correspondence and accounts. This is important. Samuel was literate. Catherine was literate. And in a world where literacy was power, where the written word was the tool by which laws were made and property was transferred and histories were recorded, These two young people shared something that transcended the supposedly unbridgeable gulf between their races and their stations. They talked. We know this because of a single letter that survived, found in 1983 in an archive at the University of North Carolina. It's dated May 1827, written by Catherine to her cousin Louisa Barnwell, who lived in Savannah. The relevant passage reads, "You asked about my education and what books I have lately read. I have been studying the Greeks, particularly Aristotle's views on natural slavery, which I find troubling and paradoxical. I have discussed these matters with a friend who reads as extensively as I do, and who has shown me that Aristotle's reasoning, which supposes some men to be slaves by nature, cannot account for those who possess reason and virtue in equal measure to those born free. I cannot write more plainly than this, but I hope you understand my meaning. A friend who reads as extensively as I do." In Charleston in 1827, Catherine Wardlaw had exactly one friend who fit that description. In March of 1831, when Catherine was 22 years old, she married Robert Aldrich Wardlaw. No relation, despite the shared surname. Robert was a distant cousin, but the connection was remote enough to be socially acceptable. He was 15 years older than Catherine, a merchant who had established himself in Mobile, Alabama, a city experiencing an economic boom due to its position as a major cotton shipping port. The marriage was arranged, which was common. Catherine had no recorded objection to the match, which was also common. By the standards of the time, Robert Wardlaw was a good prospect. He was financially stable. He was reasonably healthy. He did not drink to excess or have a reputation for cruelty. Catherine's parents approved. The wedding took place at St. Michael's Church in Charleston, with 70 guests in attendance. The marriage license and church records survive. So does a brief announcement in the Charleston Courier dated March 19, 1831. Married on Thursday last by the Reverend Theodore D. Hahn, Mr. Robert A. Wardlaw to Miss Catherine E. Wardlaw, both of the city. What the announcement doesn't mention, what no public record mentions, is that when Catherine Wardlaw left Charleston for Mobile with her new husband, she brought someone with her. Samuel. According to the bill of sale dated March 15, 1831, 4 days before the wedding, Edmund Wardlaw sold Samuel to Robert Aldrich Wardlaw for the sum of $800. The document describes Samuel as a male Negro of approximately 23 years, skilled in household service and accounting, of good health and sound mind. Think about that for a moment. Catherine's father sold Samuel to Catherine's husband 4 days before the wedding. This was not unusual. It was customary for a bride's family to provide enslaved people as part of her dowry, as living property that would serve the new household. But Edmund Wardlaw didn't give Samuel as a gift. He sold him. Which means Robert Wardlaw requested the purchase. Which means he knew that Catherine wanted Samuel in her new household. Why would Robert Wardlaw agree to this? Why would a white man, a respected merchant, allow his new wife to bring along an enslaved person she had known since childhood, when surely there were plenty of enslaved people already available in Mobile? We'll never know for certain, but we can make educated guesses based on what happened later. Robert Wardlaw was a practical man. He was frequently away on business, traveling to New Orleans, to Charleston, to New York. He needed someone he could trust to manage his household and his accounts in his absence. Samuel was literate, skilled, and reliable. From Robert's perspective, this was simply a sound business decision. He didn't understand what he was actually agreeing to. Catherine, Robert, and Samuel arrived in Mobile in April of 1831. They moved into a house on Government Street, in the neighborhood where the city's merchants and professionals lived. The house was substantial, 2 stories with a wide porch, separate kitchen building, and quarters for enslaved workers behind the main residence. Mobile was smaller than Charleston, but it was growing fast. Cotton was flooding through the port, and fortunes were being made overnight. Robert thrived. Within 2 years, he had expanded his business to include not just cotton trading, but also shipping contracts, warehouse management, and property speculation. He was elected to the Mobile Chamber of Commerce. He joined the Masonic Lodge. He became exactly the kind of man who mattered in a city that cared about commerce above all else. Catherine did what was expected of her. She managed the household. She entertained Robert's business associates and their wives. She attended Christ Church, the Episcopal congregation that served Mobile's elite. She joined the Mobile Female Benevolent Society, which provided charity to poor white families. She had no children. This was noted, commented upon, and eventually became a source of quiet speculation. In June of 1835, a woman named Harriet Chambers wrote to her sister in Virginia, "Mrs. Wardlaw remains childless after 4 years of marriage. One wonders if she is barren or if there is some other impediment. Mr. Wardlaw seems resigned to his fate, though one can see it weighs upon him." But here's what no one outside the Wardlaw household knew. Catherine and Samuel were still talking, still reading together, still occupying a space that existed parallel to the official world of masters and slaves, a space that had no name and no legal recognition, but was nevertheless real. We know this because of an incident that occurred in December of 1835. A white overseer named James Brennan, who managed one of Robert Wardlaw's warehouses, came to the house on Government Street to deliver some papers. Samuel answered the door. Brennan asked to speak to Mr. Wardlaw. Samuel explained that Mr. Wardlaw was away on business in New Orleans and would not return for 2 weeks. Brennan asked if he could leave the papers with Samuel. Samuel said he would ensure Mr. Wardlaw received them upon his return. Here's what made this incident noteworthy enough to appear in Brennan's diary, which was found in 1991. Samuel spoke to him not as a slave to a white man, but as one household manager to another. He used formal language. He made direct eye contact. He did not step aside or lower his gaze. And when Brennan made a dismissive comment about the papers being too complicated for a colored boy to understand, Samuel replied, "I believe I am capable of securing their safekeeping, sir." Brennan was disturbed by this. He wrote in his diary, "The boy speaks like a white man. I mislike it. Wardlaw permits too much freedom in his house." But Brennan said nothing to Robert Wardlaw. He needed the job, and besides, what Samuel was doing wasn't technically illegal. Enslaved people in cities often operated with considerable autonomy. They hired themselves out, kept their own money, moved through the streets without constant supervision. The system relied on a paradox. Enslaved people were supposedly incapable of self-governance, yet they were routinely expected to govern themselves. Still, there were limits, and Samuel was approaching them. On August 14, 1841, Robert Aldrich Wardlaw died. He was 47 years old. The cause of death was listed as fever, which in 1841 could mean malaria, typhoid, yellow fever, or any number of other diseases that regularly swept through southern port cities. He died at home, nursed by Catherine and attended by Dr. Josiah Knott, one of Mobile's most prominent physicians. The funeral was held at Christ Church. Over 100 people attended. Robert Wardlaw was buried in Magnolia Cemetery, in a plot he had purchased 3 years earlier. The Mobile Register ran an obituary praising his industry and integrity, and noting that he was universally respected by all who knew him. Catherine was 32 years old. She had been married for 10 years. She had no children. And according to Robert's will, which was probated on August 30th, 1841, she inherited everything. The house on Government Street, the warehouse on Water Street, the shares in 3 different shipping companies, the accounts at the Bank of Mobile, totaling approximately $18,000, and 11 enslaved people, including Samuel. This was unusual but not unprecedented. Typically, a widow would inherit a life interest in her husband's property, meaning she could use it but not sell it, and it would pass to other heirs after her death. But Robert had no children, and his only surviving brother, William, had moved to Texas and showed no interest in his affairs. So Catherine inherited outright. She was now a woman of property, which meant she had power. Not the kind of power that men had. She couldn't vote, couldn't serve on juries, couldn't enter into certain kinds of contracts without a male guardian's approval. But she had economic power. She could support herself. She didn't need to remarry. And yet, within 3 months of Robert's death, she began the process of freeing Samuel. The legal mechanism for freeing an enslaved person was called manumission. In Alabama in 1841, manumission was difficult but possible. It required a formal petition to the county court, an explanation of the reasons for the manumission, proof that the person being freed would not become a burden on the public, and approval from a judge. Additionally, any freed person was required by law to leave the state within 1 year or face re-enslavement. Catherine filed her petition on November 2, 1841. The document still exists in the Mobile County archives. It reads, in part, Catherine E. Wardlaw, widow of Robert A. Wardlaw deceased, respectfully represents that she is the lawful owner of a certain male slave named Samuel, aged approximately 33 years, and that the said Samuel has served her household faithfully and with distinction for the past 10 years. The said Samuel is of good character and possesses skills in reading, writing, and accounting, which will enable him to support himself as a free man. Petitioner requests that the court grant manumission to the said Samuel, and that he be permitted to remain in the state of Alabama as a free person of color. The petition was heard by Judge Samuel Grayson on November 18, 1841. The hearing lasted less than 15 minutes. Judge Grayson asked Catherine 3 questions. Was Samuel literate? Yes. Did she have means to support him if he could not find employment? Yes. Did she understand that freed Negroes often became a source of discontent among the enslaved population? Yes, she understood. Judge Grayson approved the manumission. Samuel became legally a free man. But here's the thing that historians puzzled over for years. Catherine also filed a second petition on the same day. This petition requested that Samuel be exempted from the requirement to leave Alabama within 1 year. She argued that Samuel was essential to the management of her late husband's business affairs, that he possessed unique knowledge of the warehouse operations and shipping contracts, and that his departure would cause financial hardship. This was a more difficult request. Judges rarely granted such exemptions because the entire legal structure of slavery rested on the assumption that free black people were dangerous. They might inspire enslaved people to rebel. They might refuse to show proper deference to whites. They might, simply by existing, prove that black people were capable of everything that white people said they were not capable of. But Judge Grayson granted this petition too. Why? We don't know for certain, but we can piece together some educated guesses. Catherine was a widow of good reputation. She was white, which meant her word carried weight that Samuel's never could. She was managing a substantial business estate, and the court had an interest in ensuring that the estate remained productive and tax-paying. And perhaps most importantly, Judge Grayson had known Robert Wardlaw personally. They were both Masons. They had attended the same church. The court granted Catherine's request. Samuel was freed and permitted to remain in Alabama. On November 19, 1841, Samuel walked out of the Mobile County Courthouse as a free man. He had been enslaved for 33 years. Now he was free. He could earn wages. He could own property. He could testify in court, though only in cases involving other black people. He could not vote. He could not serve on a jury. He could not marry a white woman. That last point is crucial. Remember it. Samuel moved into a boarding house on State Street in the section of Mobile where free people of color lived. He began working for Catherine as a Sayhais paid employee, managing the warehouse operations that he had previously managed as enslaved property. He was paid $30 a month, which was a decent wage for the time. He opened an account at the Bank of Mobile, which accepted deposits from free people of color as long as they could prove their free status. For 6 months, this arrangement continued. Catherine managed her late husband's estate. Samuel managed the warehouse. They saw each other daily for business purposes. They maintained the fiction that the relationship was purely professional. And then, in May of 1842, something changed. We need to be very careful here, because the historical record is incomplete and it's very easy to impose modern narratives onto past events. It's easy to imagine a secret romance, clandestine meetings, passionate declarations. It makes for a better story. But that's probably not what happened. What we know for certain is this. In May of 1842, Catherine Wardlaw began divesting herself of her late husband's business interests. She sold the warehouse to a consortium of merchants for $11,000. She sold her shares in 2 of the 3 shipping companies. She converted most of her remaining assets to cash and government bonds. This caught people's attention. Mobile was a small city, and financial transactions of this magnitude were noticed and discussed. Why would a widow liquidate a profitable business? Was she planning to leave Mobile? Was she in financial trouble? A woman named Sarah Gale, wife of Alabama Governor John Gale, wrote in her diary on May 23, 1842, "Mrs. Wardlaw has sold the warehouse on Water Street. There is speculation that she plans to remove to Charleston or perhaps to New Orleans. Others say she has made unwise investments and must sell to cover her debts. I cannot say which rumor has more truth to it." Neither rumor was correct. On June 3, 1842, Catherine met with a lawyer named Thomas Easton. We know this because Easton kept meticulous records of all his client meetings, and these records were preserved when his practice was absorbed by another firm in the 1850s. The purpose of the meeting, according to Easton's notes, was to discuss the legal ramifications of a proposed marriage to a free person of color. Think about that. Catherine Wardlaw sat in a lawyer's office and asked about the legal ramifications of marrying Samuel. Easton's notes continue. Advised client that marriage between white persons and Negroes or persons of mixed blood is prohibited by Alabama statute. Code of 1838, Section 2612. Any person who performs or officiates at ceremony of marriage is subject to fine. Advised client that no legal marriage could be contracted within the state. Client thanked me for my time and departed. Catherine paid Easton $5 for the consultation. She never returned to his office. For 3 weeks, nothing happened. At least nothing that left a trace in the historical record. Catherine continued to manage her affairs. Samuel continued to work, though he was no longer managing the warehouse Catherine had sold. He took on work as a clerk for other merchants, which was one of the few occupations available to free black men in Mobile. And then, on June 28, 1842, Catherine and Samuel disappeared from Mobile. They left no note. They told no one they were leaving. They simply vanished. When Catherine's housekeeper arrived at the Government Street house on the morning of June 29th, she found it empty. The furniture was still there, the linens were still on the beds, but Catherine was gone. So was Samuel. The housekeeper reported this to the neighbors. The neighbors reported it to the authorities. The authorities did precisely nothing, because there was no evidence of a crime. Catherine was a grown woman, a widow of independent means. She was entitled to go where she pleased, but people talked. The Mobile Register mentioned Catherine's departure in a brief item on July 2, 1842. Mrs. C.E. Wardlaw, relict of the late R.A. Wardlaw, has removed from this city. Her destination is unknown. The house on Government Street remains in her possession, but is presently unoccupied. That's all. No speculation about why she left or where she went. But in private letters and diaries, people had theories. Sarah Gale wrote on July 5th, Mrs. Wardlaw has fled the city in disgrace. It is whispered that she has formed an unseemly attachment to the free Negro who was formerly her property. I do not credit the more extreme rumors, but something is certainly amiss. Another woman, Mary Crenshaw, wrote to her sister in Virginia, There is a scandal concerning Mrs. Wardlaw, who has decamped with her former slave. The respectable people of Mobile are relieved by her departure, though they are careful not to speak of it too openly. These letters reveal something important. People suspected what was happening, but they couldn't quite believe it, because what they were suspecting was literally unthinkable. The social and legal structure of the antebellum South was built on the absolute separation of races, and that separation was maintained most stringently in the realm of marriage and sexuality. A white woman could be friendly with enslaved people. She could teach them to read, though this was illegal. She could nurse them when they were sick, manumit them when they proved worthy. But she could not love them, could not desire them, could not choose them. To do so was to violate the most fundamental rule of white supremacy, that white women were the property of white men, and that their purity, defined entirely in terms of their separation from black men, was the foundation of white society. If Catherine Wardlaw married Samuel, she would be committing a crime against not just Alabama law, but against the entire system that gave meaning to her existence as a white woman. And yet, that's exactly what she was about to do. Where did they go? For 137 years, no one knew. Margaret Thornhill, the graduate student who found the marriage certificate in 1979, spent 2 years trying to answer this question. She searched passenger manifests for ships leaving Mobile in June and July of 1842. She searched hotel registers in New Orleans, Charleston, New York. She searched property records, court documents, newspaper archives. Nothing. Catherine and Samuel had vanished completely for 4 months. And then, in October of 1842, they reappeared in Pittsburgh, Pennsylvania. We know this because of a letter Catherine sent to her brother, James Wardlaw, who still lived in Charleston. The letter is dated October 12, 1842, and it was discovered in a trunk of family papers in 1987. It reads, "Dear brother, I write to inform you that I am well and residing temporarily in Pittsburgh. I know you have heard rumors of my departure from Mobile, and I expect you disapprove of my actions. I cannot explain myself fully in a letter, but I hope in time you will understand that I have acted according to my conscience and my understanding of Christian duty. I have made inquiries regarding the legal status of my proposed actions. I have learned that Pennsylvania does not prohibit marriage between persons of different races, though neither does it encourage it. I have also learned that a marriage contracted legally in Pennsylvania will be recognized in some states but not in others. I intend to proceed. I ask not for your blessing, but for your silence. Do not tell mother and father where I am or what I plan to do. Let them believe I have removed to New York or Boston for reasons of health. This is a kindness I ask of you, for their sake more than my own. Your affectionate sister, Catherine." This letter tells us several critical things. First, Catherine and Samuel spent approximately 4 months researching where they could legally marry. Second, they chose Pittsburgh specifically because Pennsylvania law did not prohibit interracial marriage. Third, Catherine was aware that her family would be horrified, and she was trying to minimize their suffering. But here's what the letter doesn't tell us. Why Pittsburgh? Why not stay in Pennsylvania, where their marriage would be legal and they could build a life together? The answer lies in another document that Margaret Thornhill found in the Pennsylvania State Archives in 1982. It's a letter from Samuel to a man named Martin Delaney, who would later become a prominent African-American abolitionist, journalist, and military officer. In 1842, Delaney was a young man living in Pittsburgh, working as a physician's assistant and writing articles for abolitionist newspapers. Samuel's letter is dated October 20th, 1842. The relevant section reads, "I have come to Pittsburgh with the woman who was once my mistress and who has freed me from bondage. We wish to marry, but we understand that a marriage here, though legal, will not be recognized in Alabama, where we intend to return. She owns property there, and I have employment prospects there. We cannot build a life in the North where we are strangers and where she has no means of support beyond what she has brought with her. I write to ask your counsel on this matter. Is there a way to marry legally while also ensuring that we can return to Alabama without fear of prosecution? Or are we attempting something that cannot be done?" Delaney's response does not survive, but we can infer what he must have told them. You cannot have both. You cannot marry legally and return to Alabama. The law will not permit it. But Catherine and Samuel decided to try anyway. On November 12, 1842, Catherine Eliza Wardlaw and Samuel were married in Pittsburgh, Pennsylvania. The ceremony took place at the First Presbyterian Church, a gray stone building on 6th Street. The minister was Reverend Thomas McKinley, a young pastor who had recently arrived from New York. McKinley kept a diary, and in his entry for November 12th, he wrote, "Today I performed a marriage ceremony that I expect will cause some consternation should it become known. The bride was a white woman of good family, recently widowed. The groom was a colored man, recently freed from slavery. Both were serious in their intent and clear in their understanding of the difficulties they will face. I confess I hesitated when they first approached me. I am not certain such marriages are wise given the strong feelings they provoke. But I could find no biblical prohibition against marriage between persons of different races. Paul writes that in Christ there is neither Jew nor Greek, slave nor free. If this is true, and I believe it is, then I cannot see why there should be white or colored in the eyes of God. I performed the ceremony. 3 witnesses attended, all friends of mine who I knew would be discreet. The couple seemed happy, though there was also a sadness in their happiness, as if they knew their joy would be brief. The marriage certificate, which is how we know any of this happened, was filed with the Allegheny County Clerk's Office on November 13, 1842. It lists Catherine as Catherine E. Wardlaw, widow, age 33 of Alabama. Samuel is listed as Samuel, colored man, age 34, formerly enslaved, currently of Pittsburgh. No last name for Samuel, just Samuel, because enslaved people were not given surnames. They were identified by their first names and the names of their owners. When Samuel was freed, he could have chosen any surname he wished. Some freed people took the surnames of their former owners. Some took new names entirely. Samuel apparently chose not to take a surname at all. Or perhaps the clerk who recorded the marriage certificate simply didn't think a black man's full name mattered enough to record. After the wedding, Catherine and Samuel stayed in Pittsburgh for 2 more weeks. They lived in a boarding house on Smithfield Street. We know this because the boarding house proprietor, a woman named Eliza Morrison, mentioned them in a letter to her sister dated November 20th, 1842. I have taken in a curious pair of lodgers, a white woman and a colored man who claim to be married. They keep to themselves and cause no trouble, but their presence has occasioned some comment among my other guests. I have told them they may stay through the end of the month, but I would prefer they find lodging elsewhere after that. I do not wish to lose my other boarders, who are less tolerant of such arrangements. On November 28, 1842, Catherine and Samuel left Pittsburgh. They traveled by coach to Wheeling, Virginia, and from there they took a steamboat down the Ohio River to the Mississippi, and from there to Mobile. They returned to Alabama as a married couple. They arrived in Mobile on December 14, 1842. It was a cold morning, unusual for coastal Alabama. The steamboat docked at the wharf on Water Street, and passengers disembarked carrying trunks and bags and children. Catherine and Samuel stepped onto the dock together, and then they walked to the house on Government Street. Think about what this meant. Catherine and Samuel had just traveled over 1,000 miles. They had gotten married in a city where their marriage was legal, knowing that when they returned to Alabama, that marriage would be void. Worse than void, it would be criminal. Any person who knowingly participated in an interracial marriage could be fined or imprisoned. Any minister who performed such a ceremony could lose his license and face prosecution. But Catherine and Samuel had found what they believed was a loophole. Their marriage had been performed legally in Pennsylvania. Alabama law said that interracial marriages contracted in Alabama were void and criminal. But their marriage hadn't been contracted in Alabama. It had been contracted in Pennsylvania, where it was legal. Did that mean Alabama had to recognize it? The question of whether one state had to recognize marriages performed in another state was a matter of legal debate in the 1840s. The Constitution's full faith and credit clause required states to respect the public acts, records, and judicial proceedings of other states. But did that include marriages that violated the receiving state's public policy? No court had definitively answered this question in 1842. Catherine and Samuel were about to force the issue. They moved back into the house on Government Street. Catherine resumed her place in mobile society, or tried to. She attended church on the first Sunday after her return. She walked into Christ Church wearing a dark blue dress and a bonnet, and she sat in the pew that had been her family's pew since Robert had purchased it in 1831. People stared. Of course they stared. Catherine had been gone for nearly 6 months. Rumors had circulated, and now here she was, back in Mobile, acting as if nothing had changed. But something had changed, and everyone knew it. Reverend James Lloyd, the rector of Christ Church, asked to speak with Catherine after the service. They met in the parish office. No record of their conversation exists, but we know what happened next. Catherine stopped attending Christ Church. She never returned. This tells us something about what Reverend Lloyd must have said to her. Meanwhile, Samuel resumed his work as a clerk. He found employment with a merchant named Abraham Mordecai, who owned a dry goods store on Dauphin Street. Mordecai was Jewish, which mattered because Jewish merchants in Mobile occupied a peculiar social position. They were white, but not fully white. They were accepted in business, but not always in social settings. They were, in some ways, outsiders who understood what it meant to be marked as different. Mordecai paid Samuel $40 a month, which was more than Samuel had earned before. He also allowed Samuel to live in a room above the store, which meant Samuel didn't have to find lodging in the section of town where free black people were expected to live. But Samuel didn't live above the store. He lived with Catherine in the house on Government Street. They lived together openly as husband and wife. This was the moment when everything should have collapsed. This was when the authorities should have intervened, when the law should have come down on them with full force. But for reasons that are still debated by historians, nothing happened. Not immediately. For 3 months, Catherine and Samuel lived together in the house on Government Street, and Mobile society did nothing. This is perhaps the most puzzling aspect of the entire story. Alabama law was explicit. Section 2612 of the Alabama Code of 1838 stated, "Any white person who marries a Negro or person of mixed blood shall be guilty of a misdemeanor and shall be punished by fine not exceeding $1,000 or imprisonment not exceeding 6 months, or both." The penalty was severe. The law was clear, and yet for 3 months no one enforced it. Why? Part of the answer lies in the peculiar nature of law enforcement in 1840s Alabama. There was no police force as we would understand it today. There were constables and sheriffs, but they generally responded to complaints rather than proactively enforcing the law. Someone had to file a formal complaint before the authorities would act. And no one filed a complaint. This doesn't mean people weren't talking. They absolutely were. A woman named Elizabeth Pratt wrote to her cousin in Montgomery on January 8, 1843. "The most extraordinary scandal has developed in our city. Mrs. Wardlaw, who left Mobile last year under mysterious circumstances, has returned and is now living openly with the Negro man who was formerly her slave. They claim to have married in Pennsylvania, though, of course, no such marriage can be recognized here. The respectable people of Mobile are horrified but seem uncertain how to proceed. Mrs. Wardlaw owns her house outright and has sufficient means to support herself. She owes no debts. She has broken no laws that anyone can prove. The Negro man works and conducts himself with propriety. They do not flaunt their situation, but neither do they hide it. I confess I do not know what should be done. The situation is intolerable, yet there seems to be no clear path to resolving it. Judge Grayson, who granted the Negro his freedom, is said to be mortified but claims he cannot undo what he has done. The sheriff says he cannot arrest anyone without a formal complaint. And no one wishes to be the person who makes such a complaint, for fear of appearing overly concerned with the affairs of others. This letter reveals something crucial. The white community of Mobile was paralyzed by uncertainty. They knew Catherine and Samuel's relationship was wrong. By the standards of their society, it was profoundly wrong. But they didn't know how to stop it without creating an even larger scandal. Because here's the thing, if the authorities arrested Catherine and Samuel, there would have to be a trial. And a trial would mean testimony. And testimony would mean that the details of their relationship would become part of the public record. The newspapers would cover it. People in other cities would read about it. Mobile would become known as the place where a white woman married her former slave. The white elite of Mobile wanted Catherine and Samuel to go away. They wanted the problem to solve itself. They wanted Catherine to come to her senses, send Samuel away, and resume her proper place in society. But Catherine didn't do that. Instead, she and Samuel established a routine. Catherine managed her remaining business affairs from home. Samuel went to work at Mordecai's store each day. In the evenings, they ate dinner together. On Sundays, they did not attend church. Catherine had been effectively expelled from Christ Church, and Samuel had never been welcome there anyway. They were, as much as was possible in 1843 Alabama, living as a married couple. And then someone decided to do something about it. On March 3, 1843, Catherine's 34th birthday, a man named William Stein filed a formal complaint with the Mobile County Sheriff. Stein was not a prominent citizen. He was a warehouse clerk, the kind of man who existed at the margins of Mobile's commercial society. He had worked briefly for Robert Wardlaw before Robert's death, and he had been fired for drunkenness. He bore a grudge against the Wardlaw name, and he saw in Catherine's situation an opportunity to settle that grudge while also making himself important. His complaint was simple. Catherine Wardlaw and Samuel, a free Negro, were living together in violation of Alabama's anti-miscegenation laws. They claimed to be married, which constituted an illegal interracial marriage. The law required that they be prosecuted. Sheriff David Anderson received the complaint and was obligated to act. On March 5, 1843, he went to the house on Government Street with a deputy. Catherine answered the door. What happened next is recorded in the sheriff's official report, which still exists in the Mobile County archives. I informed Mrs. Wardlaw that a complaint had been filed, alleging that she was cohabiting with the Negro man in violation of state law. Mrs. Wardlaw stated that she was married to Samuel, a free man of color, and that their marriage had been legally contracted in Pittsburgh, Pennsylvania. She showed me a marriage certificate bearing the seal of Allegheny County. I informed Mrs. Wardlaw that Alabama does not recognize marriages between white persons and Negroes, regardless of where such marriages were performed. She stated that she believed the full faith and credit clause of the Constitution required Alabama to recognize marriages legally performed in other states. I informed her that I was not qualified to make determinations regarding constitutional law, but that I was obligated to enforce Alabama law as written. I requested that she accompany me to the courthouse to answer the complaint. She agreed without resistance. I also requested that the Negro man Samuel accompany us. Mrs. Wardlaw informed me that Samuel was at work and could be found at Mordecai's Dry Goods on Dauphin Street. I dispatched my deputy to collect him. Catherine and Samuel were arrested on March 5, 1843. They were charged with violating Alabama Code Section 2612, contracting an illegal interracial marriage. They were held overnight in the Mobile County Jail and released the next morning on bail of $200 each, which Catherine paid for both of them. Their trial was scheduled for April 15, 1843. Catherine hired two lawyers, Thomas Easton, the same lawyer she had consulted before leaving for Pennsylvania, and a younger attorney named James Campbell. Campbell was an interesting choice. He was originally from Massachusetts and had only been practicing law in Mobile for 2 years. He was known for taking unpopular cases. He had once defended a free black man accused of striking a white man, and he had won an acquittal by arguing that the white man had struck first and the black man had acted in self-defense. Campbell agreed to represent Catherine and Samuel, but he warned them that their chances of success were minimal. Alabama courts had never recognized an interracial marriage performed in another state. There was no precedent that favored their position, but Catherine insisted on fighting. She believed, or perhaps she needed to believe, that the law would recognize what had been done legally in Pennsylvania. She was wrong. In the 6 weeks between their arrest and their trial, Catherine and Samuel became the subject of intense scrutiny. Newspaper editors who had previously ignored their situation now felt compelled to comment. The Mobile Register published an editorial on March 10, 1843, that captures the tone of public opinion. The recent arrest of Mrs. C.E. Wardlaw and the free Negro Samuel has occasioned much discussion in our city. We do not relish reporting on such matters, as they are distasteful to all right-thinking persons. However, the facts of the case demand attention. Mrs. Wardlaw, a woman of respectable family and adequate means, has seen fit to contract what she terms a marriage with a man who was, until recently, her property. That this union was performed in a northern state where such abominations are permitted does not make it less repugnant to the laws of Alabama and the sentiments of her people. We trust that the court will uphold the clear language of our statutes and will impose appropriate penalties upon both parties. The purity of our society depends upon the maintenance of proper boundaries between the races. When these boundaries are violated, particularly by those who should know better, the violation must be corrected swiftly and publicly. Other newspapers were even harsher. The Montgomery Advertiser called Catherine a traitor to her race and her sex. A newspaper in Charleston, Catherine's hometown, published a brief notice stating that the Wardlaw family disavows all connection with Catherine and considers her dead to us in all respects save the legal. Catherine's family had formally disowned her, but Catherine was not without supporters, though they were few and had to be careful about expressing their support publicly. Martin Delaney, the abolitionist whom Samuel had written to in Pittsburgh, published an article in a newspaper called The Mystery on March 24, 1843. The article didn't mention Catherine and Samuel by name, but the reference was obvious. We have learned of a case in Alabama where a white woman and a black man, legally married in Pennsylvania, are being prosecuted for the crime of being married. Let us be clear about what this case represents. It is not about law. It is about power. It is about a system that cannot tolerate the idea that a white woman might choose a black man, that a black man might be worthy of such a choice. The prosecutors will argue that Alabama law must be upheld. But what they are really defending is not law, but slavery's logic. That black people exist only to serve white people. That white women exist only to bear white children. That any deviation from these roles threatens the entire edifice of white supremacy. We pray for justice in this case, though we do not expect it. Deloney was right not to expect justice, because the legal situation was clear, even if the moral situation was not. James Campbell, Catherine's attorney, spent the weeks before trial researching every possible legal argument. He found a few cases from northern states where courts had recognized marriages that violated local public policy, but had been contracted legally elsewhere. But he found no southern cases, and he found no cases specifically addressing interracial marriage. He also found something else: a constitutional argument. The full faith and credit clause of the Constitution requires states to give full faith and credit to the public acts, records, and judicial proceedings of other states. A marriage certificate was a public record. Pennsylvania had issued Catherine and Samuel a legal marriage certificate. Didn't Alabama have to recognize it? The problem with this argument was that courts had consistently held that the full faith and credit clause didn't require states to recognize marriages that violated their fundamental public policy. And in Alabama in 1843, nothing was more fundamental to public policy than the separation of races. Campbell knew his argument would fail, but he prepared it anyway because Catherine insisted. She had to believe that the law could be made to see reason. Samuel, on the other hand, had no illusions. He had lived his entire life under a legal system that considered him property. He understood that the law was not an instrument of justice, but an instrument of power. He expected to lose. He expected to be punished. What he didn't expect, what neither of them expected, was how severely they would be punished. The trial began on April 15, 1843, in the Mobile County Courthouse. The courtroom was packed. Over 200 people attended, filling every seat and standing along the walls. The crowd was almost entirely white, though a few free people of color were permitted to stand in the back of the room. The judge was Robert Ligon, a 53-year-old jurist who had served on the Alabama bench for 12 years. He was known as a fair judge, which in 1843 Alabama meant that he followed the law as written without inserting his personal opinions unless absolutely necessary. The prosecutor was William Crawford, the Mobile County solicitor. Crawford was 38 years old, ambitious, and politically connected. He saw this case as an opportunity to demonstrate his commitment to Alabama's racial order and to advance his political career. Catherine and Samuel sat at the defense table with their attorneys, Thomas Easton and James Campbell. Catherine wore a simple gray dress and no jewelry. Samuel wore the suit he had been married in, which was the only formal clothing he owned. The trial began with opening statements. Crawford spoke first. His statement was brief and clear. "Gentlemen of the jury, the facts of this case are not in dispute. The defendants admit that they participated in a ceremony of marriage in Pennsylvania. They admit that they have lived together as husband and wife since returning to Alabama. They admit that Mrs. Wardlaw is a white woman and that the defendant Samuel is a Negro. Alabama law is clear. Section 2612 of the Alabama Code states that any white person who marries a Negro is guilty of a misdemeanor. This law does not say any white person who marries a Negro in Alabama. It says any white person who marries a Negro. Period. The Location of the ceremony is irrelevant. The defense will argue that because the marriage was performed legally in Pennsylvania, Alabama must recognize it. But this argument fails for a simple reason. Alabama has the right to determine what marriages it will recognize within its borders. No state can be compelled to recognize a marriage that violates its fundamental public policy. And make no mistake, gentlemen, the prohibition on interracial marriage is fundamental to Alabama's public policy. It is fundamental to the preservation of our social order. If this marriage is allowed to stand, it will open the door to similar unions. It will send a message that white women may marry Negro men with impunity. It will undermine the very foundations of our society. I ask you to find the defendants guilty and to impose the maximum penalties permitted by law. Crawford sat down. Judge Ligon turned to the defense table. James Campbell stood. He was a tall man, thin, with dark hair that he wore longer than was fashionable. He looked at the jury, 12 white men, all property owners, all the kind of men who had a stake in maintaining the existing social order. He began, "Gentlemen, my client Mrs. Wardlaw has asked me to defend her, and I have agreed to do so, though I know this is not a popular cause. I want to begin by addressing what I expect many of you are thinking. How can I defend a white woman who has married a Negro? How can I ask you to uphold a marriage that seems to violate everything we have been taught about proper relations between the races? The answer is simple. I am not asking you to approve of this marriage. I am not asking you to believe that such marriages are wise or desirable. I am asking you only to recognize that this marriage was performed legally in a state that permits such marriages, and that under the Constitution of the United States, Alabama must give full faith and credit to legal acts performed in other states. The full faith and credit clause is not a suggestion. It is a requirement. It binds the states together into a single nation. Without it, we would have chaos. Marriages recognized in one state but not another. Contracts honored in one state but not another. Judgments enforced in one state but not another. The prosecution argues that Alabama can refuse to recognize this marriage because it violates Alabama's public policy. But where does that exception end? If Alabama can refuse to recognize a legal Pennsylvania marriage, can Pennsylvania refuse to recognize a legal Alabama marriage? Can Massachusetts refuse to recognize Alabama's laws regarding slavery? Can each state decide for itself which laws of other states it will honor and which it will reject? This is not a case about whether interracial marriage is moral or immoral. This is a case about whether the United States is truly a union of states or merely a collection of independent jurisdictions that cooperate only when it suits them. I ask you to consider this carefully. The marriage before you was legal where it was performed. Alabama law does not prohibit recognition of out-of-state marriages. It prohibits contracting such marriages in Alabama. Mrs. Wardlaw and Samuel did not contract their marriage in Alabama. They contracted it in Pennsylvania, and they returned to Alabama as a married couple. Under the Constitution, you must recognize that marriage. Campbell sat down. The courtroom was silent. Several jurors looked uncomfortable. Judge Ligon's expression was unreadable. The trial proceeded to witness testimony. The prosecution called its first witness, William Stein, the man who had filed the original complaint. Stein testified that he had observed Catherine and Samuel living together in the house on Government Street. He testified that neighbors had told him the two were claiming to be married. He testified that such a situation was offensive to the community and dangerous to the social order. Under cross-examination, Campbell asked Stein a series of questions. Mr. Stein, did you personally observe Mrs. Wardlaw and Samuel engaging in any illegal activity? They were living together as man and wife. That's illegal. But did you observe them engaging in any specific act that violated the law? I just told you. Did you see them sign a marriage certificate? Did you observe a marriage ceremony? No, but... So your testimony is based entirely on what other people told you and on your interpretation of their living arrangements? Everyone knows what they're doing. Everyone knows or everyone assumes? Judge Ligon sustained an objection from the prosecution, but the point had been made. Stein had no direct knowledge of anything except that Catherine and Samuel lived in the same house. The prosecution's second witness was Sheriff David Anderson, who testified about arresting Catherine and Samuel. He described the marriage certificate they had shown him. He confirmed that the certificate appeared to be legitimate, bearing the seal of Allegheny County, Pennsylvania, and the signature of Reverend Thomas McKinley. Campbell declined to cross-examine. There was no point. The sheriff's testimony actually supported the defense's case because it established that the marriage had been legally performed in Pennsylvania. The prosecution's third witness was Reverend James Lloyd of Christ Church. This testimony was more damaging. Reverend Lloyd testified that he had spoken with Catherine after her return to Mobile. He said that Catherine had told him she had married Samuel in Pennsylvania. He said he had explained to her that such a marriage could not be recognized in Alabama, and that her continued cohabitation with Samuel was sinful. And what was Mrs. Wardlaw's response? Crawford asked. She said that she believed her marriage was legal and that she intended to honor her vows. Did she show any remorse? Any understanding that her actions were wrong? No, she seemed quite resolved in her course. Did you advise her of the consequences of her actions? I did. I told her that she would be expelled from the church and shunned by respectable society. I told her that she was endangering her immortal soul. And still she refused to renounce this so-called marriage? She did. Campbell's cross-examination was brief. Reverend Lloyd, did Mrs. Wardlaw tell you that she loved Samuel? The prosecutor objected. Judge Ligon overruled it. Yes, Reverend Lloyd said quietly. She said that she loved him and that she believed God recognized their union, even if the state of Alabama did not. Thank you, Reverend. No further questions. The prosecution rested its case. James Campbell called only two witnesses, Catherine and Samuel. Catherine testified first. She was calm, composed, and direct in her answers. Campbell asked her to describe how she had met Samuel. She explained that Samuel had been born in her father's household and had been transferred to her husband's household when she married. She described Samuel's role in managing her late husband's business affairs. She described the decision to free him after her husband's death. And when did you begin to think of Samuel as something other than a servant? Campbell asked. I don't know that I can name a specific moment, Catherine said. We had known each other since childhood. We had talked about books, about ideas, about matters of faith and philosophy. Over time, I came to realize that I valued his companionship more than I valued the companionship of anyone else in my life. I came to love him. The courtroom stirred. Several spectators whispered to each other. Judge Ligon rapped his gavel. And you decided to marry him? Campbell asked. Yes. Knowing that such a marriage would be illegal in Alabama? I believed it would be legal if it were performed in a state where such marriages were permitted. I believe the Constitution required Alabama to recognize it. Do you regret your decision? Catherine was silent for a long moment. Then she said, I regret the pain it has caused my family. I regret that we are here, facing prosecution for what I believe is no crime. But I do not regret marrying Samuel. He is a good man. He has shown me more kindness, more respect, more genuine partnership than I ever experienced in my first marriage, which was sanctioned by church and state alike. This statement caused an uproar. Several men in the gallery shouted objections. Judge Ligon called for order and threatened to clear the courtroom. Crawford's cross-examination was harsh. He asked Catherine if she understood that she was undermining the social order. He asked if she had considered the effect her actions would have on other enslaved people who might now believe that they could aspire to marry white women. He asked if she believed herself to be superior to the laws of Alabama. Catherine answered each question calmly. She said she believed in the rule of law, which was precisely why she had married in a state where such marriages were legal. She said she did not believe her marriage would cause enslaved people to rebel, because her marriage was based on mutual respect between two free people. She said she was not superior to the laws of Alabama, but she believed Alabama's laws were subject to the Constitution. When Crawford finished, Catherine stepped down from the witness stand. She looked exhausted but unbroken. Samuel testified next. He was asked to describe his relationship with Catherine. He spoke carefully, aware that every word would be scrutinized, that any sign of presumption or pride would be held against him. Mrs. Wardlaw and I have known each other since we were children, he said. She treated me with kindness when others did not. When she freed me, I was grateful. When she asked me to accompany her to Pittsburgh, I went. When she told me she wished to marry me, I was honored and also afraid. Afraid of what? Campbell asked. Afraid that we would be punished for it. Afraid that she would suffer because of me. I told her we should not marry, that it would bring trouble upon her. But she insisted. She said she had made her choice, and her choice was to marry me. And you agreed? Yes. Why? Samuel looked at Catherine. Then he looked back at Campbell. He said, Because I love her. Because she offered me something I never thought I would have. A partnership built on respect and affection rather than ownership. Because she saw me as a man, not as property. How could I refuse that? Crawford's cross-examination focused on Samuel's literacy, his employment, his movements through the city. Crawford was trying to paint a picture of Samuel as someone who had been given too much freedom, who had failed to recognize his proper place, who represented a threat to the established order. But Samuel answered each question with dignity. He acknowledged his literacy. He confirmed his employment. He described his life as a free man. He did not apologize for any of it. When he stepped down from the witness stand, the defense rested. Closing arguments began late in the afternoon of April 16, 1843. The courtroom was still packed, though the crowd had shifted slightly. Some spectators had left, exhausted by the emotional intensity of the testimony, and others had arrived, drawn by word that the trial was nearing its conclusion. William Crawford, the prosecutor, spoke first. His closing argument lasted 45 minutes. He began by reviewing the facts of the case, emphasizing that Catherine and Samuel had admitted to everything the prosecution had accused them of. They had participated in a marriage ceremony. They lived together as husband and wife. They showed no remorse. Then Crawford turned to the law. Gentlemen of the jury, the defense has attempted to confuse you with arguments about the Constitution and the full faith and credit clause. Do not be confused. The law is simple. Alabama has the right to determine what marriages it will recognize. Alabama has decided through its elected legislature that marriages between whites and Negroes are prohibited. This is not merely a law, it is a reflection of our deepest values, our understanding of the natural order, our commitment to preserving the purity of the white race. If you find for the defense, you are saying that Alabama has no right to determine its own laws regarding marriage. You are saying that any couple who wishes to evade Alabama law need only travel to another state, participate in a ceremony there, and return to Alabama with impunity. You are saying that Alabama's sovereignty means nothing. But there is a larger issue at stake here. This case is not merely about two individuals who wish to live together. It is about the preservation of our entire social system. The separation of races is not arbitrary. It is essential. It prevents the degradation of the white race. It maintains order. It preserves civilization itself. The defense has asked you to sympathize with Mrs. Wardlaw and Samuel. They have portrayed this as a love story. But love does not excuse lawbreaking. Love does not override the needs of society. Love, when it crosses certain boundaries, becomes something dangerous, something that must be stopped before it spreads. I ask you to find the defendants guilty. I ask you to send a message that Alabama will not tolerate such unions. I ask you to protect our society from those who would undermine it, even if they do so in the name of love. Crawford sat down to scattered applause from the gallery, which Judge Ligon immediately silenced. James Campbell rose for the defense's closing argument. He looked tired. He knew he was going to lose. But he spoke anyway. Gentlemen, I will not insult your intelligence by pretending that Mrs. Wardlaw and Samuel's marriage is popular or widely accepted. It is not. Most people in this courtroom believe their marriage is wrong. Many of you probably believe it is wrong. But the question before you is not whether their marriage is right or wrong. The question is whether it is legal. Mrs. Wardlaw and Samuel were married in Pennsylvania, where such marriages are legal. They did not marry in Alabama. They did not violate Alabama law in contracting their marriage. They simply returned to Alabama as a married couple, expecting that Alabama would recognize what Pennsylvania had sanctioned. The prosecutor has argued that Alabama has the right to refuse to recognize marriages that violate its public policy. But where is the limiting principle? If Alabama can refuse to recognize a legal Pennsylvania marriage, what stops Pennsylvania from refusing to recognize legal Alabama marriages? What stops any state from declaring that it will only recognize marriages that conform to its particular preferences? The Constitution provides an answer. The full faith and credit clause. This clause requires states to recognize the legal acts of other states, even when those acts reflect different values or different policies. This is not a weakness of our system. It is a strength. It is what allows us to be a nation rather than a collection of independent states. I am not asking you to approve of Mrs. Wardlaw and Samuel's marriage. I am asking you to recognize that it was legal where it was performed and that Alabama has no authority to criminalize what Pennsylvania has sanctioned. If you find the defendants guilty, you are saying that the Constitution's full faith and credit clause means nothing. You are saying that states can ignore each other's laws whenever those laws are inconvenient or unpopular. You are saying that we are not truly a united nation. I ask you to acquit the defendants, not because their marriage is popular, but because it is legal. Campbell sat down. The courtroom was silent. Judge Ligon instructed the jury. His instructions were clear. If the jury found that the defendants had participated in an interracial marriage and were living together as husband and wife in Alabama, they must find them guilty, regardless of where the marriage was performed. Alabama law did not recognize interracial marriages, and the court was bound to enforce Alabama law. The jury retired to deliberate at 5:30 p.m. on April 16, 1843. They returned at 6:15 p.m. They had deliberated for 45 minutes. The foreman stood. Judge Ligon asked for the verdict. "We find the defendants guilty." Judge Ligon scheduled sentencing for 1 week later on April 23, 1843. This was standard practice. It gave the judge time to consider the appropriate penalty and gave the defendants time to prepare any statements they wished to make. In the week between the verdict and sentencing, Mobile's newspapers published extensive coverage of the trial. The Mobile Register's account was typical. The jury returned a verdict of guilty after less than 1 hour of deliberation, bringing to a close one of the most extraordinary trials ever held in this city. Mrs. Wardlaw and the Negro Samuel showed no emotion upon hearing the verdict. They were remanded to custody until sentencing, which will take place next week. The verdict is a vindication of Alabama law and a rebuke to those who would undermine our social order. Judge Ligon is expected to impose substantial penalties upon both defendants, as a warning to others who might contemplate similar violations. But not everyone agreed that the verdict was just. A letter to the editor appeared in the Mobile Tribune on April 20th, signed only "A Concerned Citizen." "I attended the trial of Mrs. Wardlaw and Samuel, and I confess myself troubled by what I witnessed. The prosecution proved that the defendants were married in Pennsylvania and that they lived together in Alabama. These facts were never in dispute. What was in dispute was whether Alabama could criminalize a marriage that was legal where it was performed. Judge Ligon instructed the jury that they must find the defendants guilty if they believe the defendants had participated in an interracial marriage, regardless of where that marriage was performed. But this instruction seems to me to beg the question. The defense argued that the Constitution requires Alabama to recognize legal marriages from other states. The judge's instruction effectively told the jury to ignore this argument. I am no friend to interracial marriage. I believe it is unwise and contrary to natural order. But I am troubled by the idea that states can criminalize actions that were legal where they were performed. If Alabama can prosecute Mrs. Wardlaw and Samuel for marrying in Pennsylvania, can Massachusetts prosecute Alabama citizens for owning slaves when they visit Boston? Where does state sovereignty end and federal constitutional protection begin? These are questions that should trouble all thinking persons, regardless of their views on race or marriage. The letter was unsigned, but historians later identified the author as Thomas Easton, one of Catherine's attorneys. He had to publish anonymously because openly defending the verdict's legitimacy would have destroyed his legal practice. On April 23, 1843, Catherine and Samuel returned to the courtroom for sentencing. The gallery was even more crowded than it had been during the trial. People sensed that something significant was about to happen. Judge Ligon called the defendants to stand before him. He began his sentencing statement. Mrs. Wardlaw, Samuel, you have been found guilty of violating Alabama Code Section 2612, which prohibits marriage between white persons and Negroes. The jury's verdict is supported by the evidence and by the law. I am now required to impose sentence upon you. Before I do so, I want to address the constitutional argument raised by your counsel. The defense argue that the full faith and credit clause of the Constitution requires Alabama to recognize your marriage because it was performed legally in Pennsylvania. This argument has some surface appeal, but it fails for a fundamental reason. The full faith and credit clause does not require states to recognize acts that violate their fundamental public policy. Alabama has determined, through its elected legislature, that marriage between whites and Negroes is prohibited. This is not an arbitrary rule. It reflects the considered judgment of the people of Alabama regarding the preservation of racial purity and social order. No provision of the Constitution requires Alabama to abandon this judgment simply because another state has made a different judgment. Therefore, your Pennsylvania marriage is void in Alabama. You are living together unlawfully. You have been properly convicted. The statute provides for a penalty of up to $1,000 fine or up to 6 months imprisonment, or both. I must consider what penalty is appropriate in this case. Judge Ligon paused. He looked at Catherine and Samuel. He continued, Mrs. Wardlaw, you are a woman of education and means. You were raised in a respectable family. You had every advantage that society could provide, and yet you have chosen to violate one of society's most fundamental rules. You have not merely committed a crime. You have repudiated your race and your station. You have set an example that, if followed by others, would lead to the destruction of the social order. Your crime is aggravated by the fact that you planned it deliberately. You researched where you could legally marry. You traveled over 1,000 miles to participate in a ceremony that you knew would be illegal in Alabama. You returned to Alabama and lived openly with Samuel, showing no shame, no remorse, no recognition of the gravity of your offense. I am therefore sentencing you to the maximum penalty permitted by law, a fine of $1,000 and imprisonment for 6 months. A murmur went through the courtroom. $1,000 was a fortune in 1843, enough to buy a house, enough to support a family for years. Combined with 6 months in jail, this was a devastating sentence. But Judge Ligon was not finished. Samuel, your crime is in some ways less and in some ways greater than Mrs. Wardlaw's. You were born into slavery. You did not have the advantages of education and station that Mrs. Wardlaw enjoyed. In that sense, you are less culpable, but in another sense, you are more culpable. You knew your place in society. You knew that marriage to a white woman was forbidden. And yet you accepted Mrs. Wardlaw's proposal. You participated in the marriage ceremony. You returned to Alabama and lived as her husband. In doing so, you have violated not just the law, but the natural order itself. You have presumed to claim a privilege, marriage to a white woman, that is reserved for white men. You have demonstrated the worst aspects of the Negro character: presumption, ambition beyond your station, refusal to accept the boundaries that society has established for your own good and for the good of all. I am sentencing you to a fine of $1,000 and imprisonment for 6 months. Additionally, because you are a free Negro who has demonstrated your unwillingness to live peacefully within the bounds society has established, I am ordering that upon completion of your jail sentence, you must leave the state of Alabama within 30 days or face re-enslavement. The courtroom erupted. Samuel swayed slightly, but remained standing. Catherine reached for his hand, but a bailiff stepped between them. Judge Ligon rapped his gavel. He concluded, "This court is adjourned." Catherine and